How's it going? So like all the people in the cannabis movement and that they're all screwing this week because it's come out that UK is the world's largest producer of legal cannabis. A drug reform group slams the government for maintaining cannabis has no medical uses while allowing its export abroad. Right, so this is to do with GW Pharmaceuticals. Yeah, they've got a few plots up and down the country, and they're just selling bare weed. Like it says how much here, 67 tons, I think. Oh no, 22 point was 95 tons of legal cannabis in 2016, more than double the total of the previous year. So, when I got nicked here for growing weed, I fucking I could I, and I had to figure out my defence. Like the first thing I thought was, well, how come GW Pharmaceuticals can sell it and I can't? Yeah. And basically, the answer that I got, like this was when I've in one of the hearings, I think that I went to. He said because they've got a license. Have you got a license? I said no, I ain't. They said well then. But then I've come home, done some more research, and I found out about this competition law. Uh, Competition law in the UK. You know what I mean? You've got the Office of Fair Trading and that. Like all competition law, that in the UK has three main tasks: prohibiting agreements or practices that restrict free trading and competition between business entities, banning abusive behaviour by a firm dominating a market or anti-competitive practices that tend to lead to such a dominant position. Yeah. So the fact that GW Pharmaceuticals is even operating is completely against competition law. Yeah, that's number one. Yeah, it's completely against the concept of competition law because there's no other, it hasn't got no competition. Anybody else who grows weed gets nicked. Yeah, anybody who applies for a license gets rejected. Like, but it ain't only that. Like now, the recent case law, the precedent case law for cannabis is Quell 2005. Yeah. And this is the precedent. Right. Five appeals were jointly heard with one Attorney General reference. Each case was concerned with the applicability of the defence of necessity in relation to offences involving possession, cultivation, production and importation of cannabis. In all the appeals, the appellants argued that cannabis was for medical purposes for the relief of pain for various medical ailments, including HIV, multiple sclerosis, and severe back pain. To have prescribed drugs of the 1971 Act and the consequential provisions of the misuse dealing with the importation set out in paragraph 11 above. But under section 7, subsection 4, the Secretary of State may exclude the operation of section 7, subsection 3 in relation to the drug, if of the opinion that it is in the public interest that its production, supply and possession should be wholly or partly unlawful, or unlawful except for purposes of research and other special purposes, or except under a license or authority issued by him. Cannabis resin, and most cannabinoids are under SI 2001 and SI 2 designated as drugs which may only be used for medical or scientific research, and as to drugs which section 7 and subsection 4 of the 1971 Act applies. The effect of that designation is that whatever benefits might be perceived or suggested for any individual patient, if these particular drugs were available for medical prescription and use other than research, such individual benefits were and are the legislator's view outweighed by the disbenefits of strength sufficient in the national interest to require a general prohibition. So that to me is just saying that there isn't a defence. You know what I mean? There is held, look, neither defence of necessity nor duress of circumstances was applicable in such circumstances. So what to me, like what I read from that is that what these done, the defence of necessity or duress of circumstances wasn't applicable. Neither the defence of necessity nor duress of circumstances was applicable in such circumstances. So look here, it says except under a license or other authority issued by him. Yeah. So GW Pharmaceutical have got a license, haven't they? Nobody else can get one. So like I've already said, it's completely against competition law and this case law. This is called the case of the monopolies. It's Darcy versus Allen. Now let me read it to you. This was like years ago in like 1602. Yeah. The plaintiff Edward Darcy, agreeing with the Chamber in the court of Queen Elizabeth, received from the Queen a licence to import and sell all playing cards to be marketed in England. This arrangement was apparently secured in part by the Queen's concern that card playing was becoming a problem among her subjects and that having one person control the trade would regulate the activity. When the defendant, Thomas Allen, a member of the Worshipful Company of Haberdashers, sought to make and sell his own playing cards, Darcy sued, bringing an action on the case for damages. The Queen's Bench Court delivered judgment for the defendant, resolving that the Queen's grant of a monopoly was invalid for several reasons. 1. Such a monopoly prevents persons who may be skilled in a trade from practicing their trade and therefore promotes idleness. Grant of a monopoly damages not only tradesmen in that field, but everyone who wants to use the product, because the monopolist will raise the price but will have no incentive to maintain the quality of goods sold. 3. The Queen intended to permit this monopoly for the public good, but she must have been deceived, because such a monopoly can be used only for the private gain of the monopolist. Sound like any companies, you know? It would set a dangerous precedent to allow trade to be monopolised, particularly because the person being granted the monopoly in this case knew nothing about making cards himself, and where there was no law that permitted the creation of such a monopoly. Now, when I showed this to the judge at Snaresbrook Crown Court, like, you had to put, like, I think it was called a defence statement in. And now, even though you've got the Quell 2005 that basically says, like, there is no defence, the judge told me, he said, you have clearly got a defence here. Yeah. But what he was saying to me was, he was saying, but it's not going to work in this court. You need to do this in the appeal court. And I was like, oh, no, we're going to do it here. We're going to do it here. Like, you know what I mean? Just being a dickhead about it. And I never appealed. I should have appealed, like, you know what I mean? But I never did. And anyway, I just thought, like, I've not seen nobody else really talk about this case, you know what I mean? And I just thought I'd throw it out there. Judges have told me that it's a defence. In the lower courts, all the lower courts he's concerned with is like the Crown Court I'm talking about. The first court, like, you go magistrates in Crown, you have your trial in Crown if it's a criminal case. And what I mean is, like, that's still the lower court. That's still the lowest court. You need to battle up through the courts, up to the Supreme Court. You know what I mean, or fucking whatever it's called. I don't know. Like, I just thought I'd put it out there, man, see what people think. Competition law as well. Where's that gone? I've closed it. But competition law as well. The Office of Fair Trading and that. I sent an email to the Office of Fair Trading saying about GW Pharmaceuticals and that, and I sent them all this as well. I sent them links to this and, like, the sections of the law that applied. Like, the section of competition law was that I found, it was saying, like, if a company is acting in a way that oh, fuck's sakes, let me find it, man, so I'll get it right. Abuse of a dominant position. That's it. Abuse of a dominant position. Competition law. Yeah, look, loads on it. You know what I mean? Have a look for yourself.